Hello, a warm welcome to all our viewers. It gives me immense pleasure to be giving this session on three important documents which are prepared by the resolution professional under the IBC, primarily the Information Memorandum, the EOI, which is the expression of interest, and the request for resolution plan. Before I, start details about the information memorandum, what is an EOI, what is a request for resolution plan, before I would like to actually speak about what is the Insolvency and Bankruptcy Code, because the Insolvency and Bankruptcy, for the first 5 minutes, I'll give a synopsis of the IBC, wherein the Insolvency and Bankruptcy Code has been a paradigm shift, wherein the underlying spirit of the code is resolution and not liquidation. So this is a code which had been defined with a defined time frame, and primarily for reorganization of the corporate debtor, and it is a time bound process, and the main principle on which it is based is that there is maximization of the value of the assets, and it balances the interest of all the stakeholders, and of course, there is alteration in the order of priority of the payments and also to the government departments. Now, the key fundamentals of this code are that there is a moratorium, there is a committee of creditors which is benefiting for all the stakeholders. It is primarily of the financial creditors, and this code has primarily been promulgated so that it promotes entrepreneurships, and there is a resolution plan for the corporate debtor which becomes binding on all. So now what you can see on your screen is what a corporate insolvency resolution process looks like, and wherein there is, it starts with the application of of insolvency, and the corporate debtor gets admitted. The interim resolution professional, which is the IRP, gets appointed, who forms the committee of creditors, and then the RP gets appointed. Now, after this are very important aspects which we will be covering in detail, which is about the invitation for the expression of interest, the invitation for resolution plans, and then the selection and the approval of a resolution plan by the COC will happen, which the plan would get approved by the NCLT. If it does get approved, then that plan would be implemented. If it gets rejected, then there will be initiation of liquidation. So this is a snapshot of what a CIRP process is all about, and what we will be discussing three important aspects, that is the information memorandum. As you can see on your screen, once a CIRP has commenced, there is a public announcement which is made, and it is the IRP who manages the affair of the corporate debtor, and he has various roles to play. The IRP has roles to play, whether he has to take control of the operations of the corporate debtor, or he has to, he's responsible for complying with the laws, he has to form a COC. And once an IRP is, confirmed to an RP, or a new RP is appointed, at that point of time, then comes the important roles of preparation of the information memorandum, then fixing of an eligibility criteria which needs to be fixed with the approval of the COC, that is for invitation of EOI, which is called a Form G, which we'll be discussing in detail. Finally, the RP would be then finalizing the RFRP, the evaluation matrix, and then the invitation of the EOI from the prospective resolutions will be done, who will be submitting their resolution plans, and finally, there will be verification of the eligibility of the PRAs, etc. But it is the resolution professional, his role which continues, where he has to release provisional list, the final list of the PRAs, and he has to take various actions. But the end purpose of the entire process is that there should be a resolution of the corporate debtor. And finally, when approval of or rejection of a resolution plan is done, then the role of the RP would conclude, or whether it is in implementation implementation of the plan by the end of it, or there is liquidation of the corporate debtor. So now I would like to basically start with what the information memorandum is all about. Now, what is an information memorandum under the IBC? Primarily, it is a memorandum which is prepared by the resolution professional. And why is it prepared? It is primarily prepared for formulating a resolution plan. So this is a memorandum. The purpose of this IM is to provide information on the company so that there is a proposed resolution plan. Now, the information which is contained in this IM could be derived from various available sources. That could be the annual reports. It could be it could be the claims what have come from the various creditors. It could be information which is publicly available. So primarily, an information memorandum, there are some statutory aspects which need to be included in an information memorandum, and which include what are the assets and liabilities, what are the audited annual financial statements, what are the financial statements for the last 2 years, what are the provisional financial statements which are made up to date, not earlier than 14 days from the date of the application. Then again, what are the list of the creditors? What are the particulars if there are any debts which are due from related parties, or if there are any details of guarantees which have been given, of the CD by anyone which is a guarantor of the related party. So all this will be a part of the information memorandum. Also, the information memorandum which is prepared under IBC would include what are the names and the addresses of partners who are holding at least 1% stake in the corporate debtor. One very important aspect which needs to be included in an information memorandum is what are the details of all the material litigations. So if there are any ongoing investigations or ongoing proceedings which are initiated by the government, by the statutory authorities, so all that needs to be included in the information memorandum. Again, because the reason is this information memorandum is prepared so that a resolution applicant gives a plan for the corporate debtor, and that plan should be based on the entire information which is available with the resolution professional. So an RP needs to make a complete efforts to provide complete details so that a proper resolution plan comes. Of course, the number of workers which are there, the number of employees, what are their liabilities towards them, all that also needs to be included in the information memorandum. Now, this information memorandum has to be submitted in an electronic form. It has to be submitted firstly to the COC, which is the Committee of Creditors, within 2 weeks of the appointment of the RP. So not later than 54th day from the insolvency commencement date. But this information memorandum, because it has a lot of information which is confidential in nature, will only be shared after an undertaking is received from the members of the COC that they will maintain the confidentiality of the information. So primarily, it is the resolution professional who will prepare this information memorandum. He will provide it also to all the resolution applicants who, giving them the access to all the relevant information which is required. Of course, after taking confidentiality undertakings, after ensuring that they protect the intellectual property of the corporate debtor. So, a model information memorandum, there are certain parts of a model which are some statutory information which we have already discussed earlier, whether it is the related sections, what are the descriptions of the assets and liabilities, what are the list of the creditors, what is the amount which is claimed by them, what is the amount which is admitted by the RP or the IRP, what is the security interest which is there, then again the dues from or to a related party, what are the guarantor details, what are the details of material litigation. This is what we just discussed right now. So these are the statutory information which ought to be included in an information memorandum, wherein the workers and how many employees are there, how many workers are there would be also there. But there is certain transaction related information. So this is something which is not statutorily required, but every IM should include an executive summary. It should, what are the key investment highlights? What is the overview of the company? What are the project details? If there is any, what is the current scenario of the company? So what is the snapshot of the financial performance, the capital structure? What are the shareholding patterns of the corporate debtor? What are the claims, the financial claims, operational claims? Then also another important aspect is if the RP is aware of there are any undervalued transactions like preferential, extortionate or avoidance transactions, fraudulent transactions, they should be a part of the information memorandum. Again, the capex requirements, the facilities, the organization structure, what is the investment overview, what are the board of directors, etc. So all this is part of a model information memorandum. Yes, there are certain requirements which are statutory requirements, but then we should, I think, as an RP, go beyond the statutory requirements and provide what are the key growth drivers, what is the snapshot of the corporate debtor, what are the sector fundamentals, if there are any future growth strategies, what is the projected business plan, so what would be the EBITDA. So accordingly, all this can be a part of a model information memorandum. Now, next, this was my first topic, which is about the information memorandum. The second topic is the invitation for EOI, which is called the Form G. Now, a resolution professional has to publish the brief particulars of an Form G, which is called the invitation of EOI, and he has to do it in not later than the 75th day from the insolvency commencement date. He has to publish it to all the interested and the eligible resolution applicants. And this Form G needs to be published, one in English language, one in the regional language at a newspaper, whereas there is wide circulation, whether it is a location of the registered office or the principal office of the corporate debtor. It needs to be published on the website of IBBI. It needs to publish on the website of the corporate debtor, if any, and also if any other manner which is decided by the COC. So a Form G is what is actually the invitation for EOI, which is the expression of interest. So this needs to state where the detailed invitation for EOI can be downloaded from. It will also provide that there has to be a minimum 15 days from the date of issue of a detailed invitation, and it will specify what is the criteria for a prospective resolution applicant. So Form G has to state what are the ineligibility norms under Section 29A. It has also to give what is the basic information of the corporate debtor. It is mentioned that it does not require payment of any fees or any non-refundable deposit for submission of an expression of interest, which is an EOI. So when we talk about the process for invitation of EOI from prospective resolution applicants, so first process is you decide what is the eligibility criteria. The eligibility criteria for a prospective resolution applicant has to be decided as per Section 25(2)(h), which is wherein with the approval of the COC. So the COC would decide, and this minimum eligibility criteria could be anything. It could be based on the minimum net worth of the individuals. It could be on the minimum AUM of the financial investment companies, or any other parameter which is decided by the COC. So the second step, once they've decided what is the invitation or what is the criteria, then a meeting will be held of the COC for discussion, and firstly, of course, on the approval, firstly on the eligibility criteria, then what would be the request for resolution plan, which is the RFRP. Again, in the COC meeting, the evaluation matrix will be decided, and other timelines, what are the refundable deposits, what is the performance security, again would be decided. Then the next step is where the publication actually happens for a Form G, which is the advertisement for the EOI. So this publication is made in Form G. It has to be uploaded again on the website of IBBI, uploaded on the website of the corporate debtor. It could also be uploaded on the website of the IP, and also if it is a listed company, then it needs to be uploaded on the website of the stock exchange. The next step is what are the main contents of a Form G. So it would include about what are the particulars of the corporate debtor, like what is its name, its date of incorporation, the SIN, the address. Then again, what are the details of the CIRP? So when did the CIRP commence? What were the dates of invitation of EOI? Till when the EOI needs to be submitted? What are the dates for a provisional list, final list, etc.? Then, what is the eligibility criteria for prospective resolution applicants for submitting the EOI? Then the details of the RP, what is the resolution professional's registration number, what is his address, what is the email ID, and then the correspondence address and email. So these are the main contents of a Form G, wherein the particulars of the corporate debtor, the particulars of the company, the particulars of the resolution professional, the correspondence address, and most importantly, what is the eligibility criteria to submit an EOI needs to be given. Again, once an EOI is received, then the same needs to be scrutinized by the RP. So the RP would make perusal of the information for basic details. Are they correct? Then he needs to verify the eligibility. Are they eligible under Section 25(2)(h) of the IBC? Then he needs to verify the eligibility under Section 29A, which would be discussed in the next half an hour. Then the verification of the confidentiality agreements, the verification of the KYC documents, and then again, if there is any refundable deposit, that receipt also needs to be taken. So finally, when the Form G has been published, then the provisional list of prospective resolution applicants would be given. It will be released to all the PRAs and to the COC members. The RP would also seek objections if there are any objections to the inclusion of the name of the prospective resolution applicant in the provisional list. And then finally, the RP will release the final list of the PRAs after receiving the objections, or if there are any no objections. So an EOI, which is an expression of interest, has to be one very important aspect, is that it needs to be unconditional. It needs to be unconditional, and it needs to be accompanied by various undertakings. And those undertakings would be primarily, firstly, are they meeting the criteria? Are they meeting the criteria of Section 29A? Are they meeting the criteria of 25(h), which is decided by the COC members? And also, they will be intimating the RP if they become ineligible at any time during the CIRP process. So, also, these undertakings have to be given by the prospective resolution applicants, that every information and record which they have provided in the EOI is true, it is correct, and if there is any false information, then of course that applicant will become ineligible, and any refundable deposit would also be forfeited, and penal action under the code would be taken against the PRA. Now also, when an EOI is given, the prospective resolution applicants have to give undertakings that they will maintain the confidentiality of the information and not use that information for cause and for undue gain or undue loss, and of all the time comply with the requirements of Section 29, subsection 2. Now, the RP, the resolution professional, will be issuing a provisional list of eligible resolution applicants. So once the IM has been issued, the EOI has been issued, it has been published in the paper, the EOI has come, then the provisional list of the eligible resolution applicants have to be finalized within 10 days of the last date of submission of EOI, and then it will be submitted to the COC members and to all the prospective resolution applicants who have submitted an EOI. So also, one important aspect is whether an EOI can be modified or not. So, yes, a modification is allowed in the invitation of EOI, and it can be made in the same manner as the initial invitation of EOI was made, but it needs to be kept into mind that such modification shall not be made more than once. Also, any expression of interest which has been received after the time specified shall be rejected. Now, there is various jurisprudence which reconfirms this fact, that any EOI which has been given after the last date shall be rejected. On your screen, what you can see is what is a draft of a Form G, which is published in the newspapers, wherein the details which we have discussed in detail right now have been included. Now I come to the last aspect of this program, which is about request for resolution plan. Now, a request for resolution plan is covered in Regulation 36B. Now, and the resolution professional would issue the information memorandum, the evaluation matrix, and the request for resolution plan within 5 days from the date of the issue of the provisional list. If you recollect, we discussed earlier when the provisional list needs to be issued, and within 5 days from the issue of the provisional list, the RFRP, the evaluation matrix, and the information memorandum will be issued. Now, this will be issued to every prospective resolution applicant who was there in the provisional list, and also to every prospective resolution applicant who has contested the decision of the RP against its non-inclusion in the provisional list. Now, basically, what all is included in an RFRP, which is the request for resolution plan? So it actually details each step in the process. So the RFRP would give what is the manner and what is the purpose of an interaction between the resolution professional and the prospective resolution applicant, and also what are the corresponding timelines. So, and the RFRP is a very detailed document which is prepared by the resolution professional, and it shall always allow a prospective resolution applicant a minimum of 30 days to submit the resolution plan. Now, a minimum of 30 days is required to submit a resolution plan, and that would be mentioned in the RFRP. And again, the RFRP shall not require any non-refundable deposit for submission of or along with the resolution plan. Now, another aspect is that the RFRP there is a performance security which needs to be given by a prospective resolution applicant, and the RFRP would require the resolution applicant, in case its plan is approved, to provide a performance security. Now, this performance security shall be forfeited if the resolution applicant, after the approval of a resolution plan, he fails to implement the plan. So, or if he contributes to the failure of the implementation of the plan in accordance with the terms, then that particular performance guarantee shall, for performance security, shall stand forfeited. Now, whether a modification of an RFRP or evaluation matrix can be done, yes, again, it can be done. It is any modification in the RFRP would be deemed to be a fresh issue, and it will be subject to, again, the timelines under sub-regulation 3. So what did the timeline say? The timeline said that yes, a minimum of 30 days to submit a resolution plan. So this provision will apply. So again, if there is any modification of the RFRP, it will be deemed to be a fresh issue, and a minimum of 30 days to submit the resolution plan again would be required, but then provided that such modification shall not be made more than once. Again, if there is the RP with the approval of the COC, can extend the timelines for submission of a resolution plan. So the RP with the approval of the COC, he can also reissue a request for resolution plan if the plans which have been received in response to an earlier request are not satisfactory. But in this case, the condition that the provisions will not apply of giving a minimum of 30 days to submit the resolution plan, but there is a condition in this that the request is made to all prospective resolution applicants who were there in the final list. So if a request is made to all those prospective resolution applicants who were there in the final list, then the reissue of RFRP can be done, and in that case the minimum of 30 days to submit a resolution plan would not be required. So now we come to, what are the brief contents of an RFRP, which we have already discussed. So primarily the details of what are the invitation of the EOI. So what is the eligibility criteria? What is eligibility criteria which has been approved by the COC? What is the eligibility criteria as per section 29A? So that has to be included in the request for resolution plan. Also, what is the manner of submission of an EOI would become a part of the RFRP. Then what are the details of submission of documents? Now, within RFRP, there is a long list of documents which you would detail that what documents are required for anyone to submit a resolution plan. So these documents would be the section 29A undertakings, the confidentiality undertakings, then documents which would support the eligibility of the prospective resolution applicants, and of course if there is any refundable deposit, if it is stipulated, then how how that has to be paid, and for the submission of the resolution plan. So all the details of all the documents which are required would be mentioned in the request for resolution plan. Also, what is the manner and the submission of the RFRP? So if there is any manner of submission of the IM, the other documents, what are the main contents and enclosures which have to be submitted along with the resolution plan? Then again, the mandatory contents of any resolution plan have to be mentioned, that these are the mandatory contents, and what are the other terms and conditions, if there are any disclaimers, any whether the plan is not submitted by a PRA, will it get approved by the COC or not? Then what are the timelines of completion of a CIRP? So all these details have to be mentioned in the RFRP. So also, the RFRP, which is the request for resolution plan, would be giving what are the details for submission of the performance guarantee. As I discussed earlier, that there is a performance guarantee which needs to be mentioned. So in case, if and how and when will it be forfeited, in case the successful resolution applicant, he fails to implement a plan which is post-approval of the COC and post-approval of the adjudicating authority. Also, minimum 30 days to PRAs have to be given to submit a resolution plan. That is something which would be mentioned in the request for resolution plan. Also, like we discussed, the RP may, with the approval of the COC, reissue an RFRP if the plans which are received in response to an earlier request are not satisfactory, subject to the condition that this request for resolution plan is made to all PRAs which are contained in the final list. So, I conclude what is the synopsis of what is an EOI, what is a request for resolution plan, and what is an information memorandum. But we need to remember that these are three very, very important documents which are prepared by the resolution professional. And the reason why these are very important is because the Insolvency and Bankruptcy Code has only been formulated to ensure that there is a resolution of the corporate debtor. So the reason the government introduced the Insolvency and Bankruptcy Code, and various jurisprudence has been formed over the years, so that there is and all these judgments reinforce that yes, the Insolvency and Bankruptcy Code is a complete code in itself, and it is very important to get resolution plans so that the corporate debtors are revived. So if there is any default, there is revival of the corporate debtor, and also which would be beneficial for all. It will be beneficial for the stakeholders, it would be beneficial for the employees, it would be beneficial for the country as a whole. And these three documents which are prepared by the RP are so important, because this is how the resolution applicant will get to know about the company. So it is the details which you are giving in the information memorandum, the what decisions you are taking in the EOI, what is the decision on the COC, what are the minimum eligibility criteria. All this is something by the end of it. That is why a resolution can be successful only if all these three documents are successfully and prepared by the RP, and they are prepared in detail. And one thing is extremely important, that any information memorandum is also a document which can be modified from time to time. It's not that if an IM is prepared, it cannot be modified. So I hope by the end of this session, you were able to understand the importance of the topic, which is the IM, the RFRP, and the EOI. And I thank you all for this opportunity, and I hope this session was beneficial. So thank you very much. Thank you once again, and have a good day. Thank you.